Okay, and Keith Murray, let me quickly bring you into the discussion. I know you're just joining us, but I want to get your take on this. Let's talk about two sides of what Jean just said. The first thing is the spectrometer used to analyze, typically, as she said, blood alcohol content, but here, using it to analyze chloroform. What does the prosecution need to say that, yes, this is normal or at least okay in testing chloroform and should be enough to have this kind of evidence and Dr. Arpad Bas testify at trial?
Gas chromatography, mass spectrometry, I always trip that. Mass spectometry, it's a mouthful. It has been around for decades. It was developed in the 1950s. It's widely established in arson investigations, drug investigations, any situation where there's an unknown substance. And basically what it does is it breaks down the constituent molecules of a substance, reads their atomic masses, and it tells you what it's made up of. This is long settled science. It's the application in this particular incidence that is causing the issues, and I think it does rely more on the opinion testimony of the expert. It's never been used to quantify an air sample for this apparent decompositional odor that Arpad Bas says he can engage in. I think it's interesting to note as well, in terms of the chloroform, it doesn't tell you how the chloroform got there. It just tells you that there's chloroform present. The chloroform could have gotten there from a pool towel if the pool was using chlorinated water. If they have chlorinated drinking water down in Florida, there's another way the chloroform could have gotten in that trunk. And the last thing I want to point out very quickly is that the defense points out that this is a qualitative test, not a quantitative test. It measured for the presence of chloroform, not how much chloroform was present in the trunk. So there are a few things in there that the defense is going to have to get over in terms of getting their expert in, but the state is, I don't think they're going to have a problem getting the technology in. It's getting around the fact that this doctor is a research scientist, and what he is doing with this science is not settled in scientific theory.
Okay, then tell us about the difference between a lab doing this kind of testing, or excuse me, like a research lab doing this kind of testing versus a forensics lab.
Sure. A forensics lab is going to have quality control. They're going to have standards. They're going to have error rates. They're going to have established scientific methodologies. In this case, he's a research scientist, and he's got a theory, and it's still, in my estimation, it still seems to be in the early stages of the theory because he's still testing it out. He's still testing it out on human remains. He's still testing it out on other types of animals. There's a lot of false positives. Rotting meat. There was trash in the trunk of this car for 18 days in the Florida heat in the summer. That could have given off false positives for some of this decompositional odor that he's talking about. So he's got to find ways to rule out these false positives, and I think it's a little early. I think he's got something here. I just think it's a little early to be allowing it in court. And in addition to that, he's not releasing his database or his research, which, as a discovery issue for the defense, I would think that alone would be causing the state huge problems.
Oh, you have to have that. That's something I absolutely want to have.
Exactly, because you have to have your own expert review this and give his competing opinion. They can't find anyone else who's done this, for one. If they're not going to release their data, they can't bring someone up to speed to try to refute this testimony. But the judge has already allowed or actually denied a discovery motion that the defense filed that would have given them access to this data and the raw research, but they won't do it.
All right, looks like Casey Anthony is back in court. The lawyers are getting ready to argue in front of the judge, or at least question the next witness on the stand. Let's return you back to the court. Answer right here. And Keith Murray, let's look at this. We're dealing with whether or not this evidence is going to be allowed at trial, and it seems to me that if it is, there's going to be a lot of controversy, or at least a lot of questioning from the defense about how reliable this kind of evidence is, especially when you're talking about a dog.
You're going to see the same kind of questioning you saw today. And I think the most significant thing here is that these dogs apparently are not trained in false positives. If the dog alerts on something and there's something there, clearly you've got proof that there's something there. You have whatever the physical, biological material is that the dog alerted on. In this case, we got a false positive. There's no telling what the dog alerted on. I know they're trained in specific ways on detecting specific odors, but he said specifically that the dog wasn't trained on fecal matter, that this dog had alerted on urine from another dog in a training exercise. So again, we get to this issue, and I know it's a flip turn of phrase, but you can't put the dog on the stand. The dog can't testify, so we don't know what the dog is hitting on when there is an absence of something physical to prove to the humans, the crime scene technicians, the forensics guys, whatever it is the dog alerted on.
Okay, we're seeing a lot of what we may end up seeing at trial when it takes place in about a month or so. Folks, let's take a quick break. When we come back, we'll have more on this issue and also talk about Dr. Arpad Voss. He's set to testify this afternoon. Stay with us. Welcome back to In Session and the hearing for Casey Anthony. Now, right now, the court is on recess. They're in lunch break. So let's talk to In Session correspondent Jean Casares. She's outside the courthouse. As well, we have with us criminal defense attorney Keith Murray. He's a former FBI analyst, and he has a background in forensic science. Now, Jean, let me start with you. This evidence that we're talking about, the canine evidence, the defense is trying to get it tossed out, trying not to have it admitted at trial. Will it have a significant effect on the state's case if, in fact, it is not allowed at trial?
I don't think so. I don't think so. I think it bolsters, it adds, but I think it's going to be controversial when it comes into trial because I think there'll be, as we've seen today, extensive cross-examination. So, no, the prosecution would probably like to have it. And, you know, whether it comes in or not, remember, this is a state of Florida cadaver dog trained and certified at a private school. So if you don't allow this in, then all the cadaver dogs in Texas are at issue for coming into trial. So I think that's one thing the judge will look at.
It's a very good point, and we already saw Linda Drain-Burdick explain the ways in which this dog is qualified, has done all these different analyses. Seems like a tough situation for the defense, at least, to get it excluded. Now let's talk about what we're expecting after the lunch break. Dr. Arpad Voss. He's going to talk a little bit. He's a forensics expert, and he's going to explain a number of things. But let's take a look at something he said a little bit earlier. Dr. Arpad Voss at one point explained what decomposition can and cannot prove. He is a person who found evidence of decomposition in Casey Anthony's car.
Decomposition can be used to answer 4 of the 5 W's that need to be answered at a crime scene. That is who, what, when, where, and why. The only thing decomposition can't help answering is why. Why did this crime occur? Or why did this person get killed?
Okay, that's Dr. Arpad Voss speaking to one of our sister networks, CNN. And, Jean, do we have any idea of what he might be addressing in his testimony this afternoon?
The primary thing is going to be the chloroform because in the trunk of Casey Anthony's car, he conducted air samples with his gas spectrometer, among other things, and determined, now here, this is going to be really fascinating because he had said that there were levels of chloroform above and beyond normal decomposition, but the defense in their motion said, wait a minute, when we deposed him, he said, you know what, I didn't test how much chloroform was in the trunk, just that there was some chloroform in the trunk. So that's an interesting question of fact, and I want to listen for that myself this afternoon, but that's the whole focus.
All right, that will be critical. And you know what, Keith Murray, as we look at this, it's a very interesting situation. We've got a doctor who is somewhat well-known in the industry, but part of the issue is going to be, as Jean mentioned, the spectrometer, his method of testing. Could make for very interesting testimony this afternoon. I'm interested, what do you think the defense will do to try to maybe knock down his testimony a little bit?
Yeah, the defense can't really touch the gas chromatography mass spectometry. That's been established practice for 60 years now. What they're going to do is attack his testimony that he's stating that there was a quantitative analysis done, or he's giving a quantitative result when it was really a qualitative analysis, meaning the qualitative analysis tests for the presence of chloroform in a sample, not the amount. And somehow, somewhere along the line, somebody got the idea that there was a lot of chloroform in this car. No one's ever said that. And even the individual that works with Dr. Vass in the lab, I believe his name is Wise, he states in his deposition that it was a qualitative, not quantitative test. So they're going to go after him on that. And I think they're also going to go after him on other substances, such as chlorinated pool water, chlorinated drinking water, household cleansers, that could also lead to a discovery of, a qualitative discovery of chloroform in a location.
Okay, should be very interesting this afternoon. Thank you so much, Keith Murray. Thank you as well, Jean. And, folks, we're doing double duty today. We're bringing you the Casey Anthony hearing, and we're also bringing you the James Ray manslaughter trial.